here that you need? Just, or we need
it-
anybody else?
It would just be Miss Lowe, although I believe, so we aren't the applicant. I believe that Mr. McMeans.
In today's courtroom breakdown, we're looking at a probate hearing focused on the admission of a will and the appointment of an executor. While this may seem like a routine legal process, each step must strictly follow procedural and statutory requirements. Let's step inside the courtroom and examine how this unfolds in real time.
McMeans planning on appearing. Miss Lowe is my client. She's going to provide testimony, and I offered to ask her the questions for Mr. McMeans, but he should also be here, I would imagine.
Okay, all right. Well, it's not 9 o'clock yet, so we're all good.
Jocelyn, this is Michelle. I'm here.
Hi, Michelle. Can you tilt your camera down so we can
Down?
see?
How's that?
No, that's up. I can
Oh.
see your light fixture.
How's that?
A little bit more. I can see your eyebrows.
Okay.
There we go. Should be just a few minutes, I would imagine. Well, I'll take 56, so.
At this early stage, the court is informally organizing appearances and confirming who will participate. This is typical in probate hearings, where procedural clarity is established before substantive matters begin.
Miss Slater, have you heard from Mr. Mestamaker? Or?
I just emailed him.
Oh.
He said, oh, he just emailed, I'm looking for the Zoom. I'll send it to him again, just so we can. I just sent it to him again. So if he hadn't found it yet, he should be.
All right, great. Now, I had this down on the docket for just being about a 5-minute hearing. Do you think
It is.
Okay.
Yeah, no, it should be. And it's just a admission of a will that incorporates the judgment you guys already found.
Right.
I offered to appear and call my client Michelle to testify to her qualifications, mainly just as a help, because I don't know that these are slightly unusual in having a will that's admitted after, a final jury trial.
Right.
So I figured I would lend my experience to Mr. Mestamaker in that regard.
Okay, he just clicked on, so hopefully he's joined. All right.
Good morning. Sorry for the
Good
delay.
morning.
I'm rather inept.
No problem. Okay, so are we just going to have Miss Lowe is going to be the only one testifying?
That's correct.
Yes, Your Honor.
Okay, so Miss
Hi,
Lowe, if I
Jocelyn.
can get you to raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I did.
Okay. Either Miss Slater or Mr. Mestamaker, whoever wants to proceed may proceed.
We'll let
Well-
the professional do this. Miss Slater will handle it.
Thank you, Mr. Mestamaker. This is Mr. Mestamaker's client's application. This is a second application after the admission of a prior will. So we would like to bring the court's attention to the final judgment that was issued by this court on March 31st, 2023, which determined that the last will and testament of James C. Lesaker dated January 15th, 2020 is
Here, counsel clarifies that the matter is a relatively straightforward probate issue, specifically the admission of a will already validated by prior judgment. This signals to the court that the hearing should be brief and largely procedural.
A valid will and executed with the proper formalities.
I'll
And
take judicial notice of that.
thank you. And then for the remaining facts to admit this will, I'd like to call my client, Michelle Lowe.
You may proceed.
Michelle, can you state your full name for the court?
Michelle Lynn Lowe.
And are you currently serving as the independent executor of the estate of James C. Lesaker?
Yes,
Did James C. Lesaker, also known as Chris Lesaker, die in Austin County, Texas on July 16th, 2021?
yes,
And that date is less than 4 years ago, correct?
yes,
And at the time of his death, did Chris have a fixed place of residence in Sealy, Austin County, Texas?
yes,
And at the time of his death, Chris was not married, is that correct?
correct.
And at the time of his death, well, let me ask another question. After January 15th of 2020, there was no marriage that was dissolved by Chris, is that correct?
Correct.
And at the time of his death, Chris had no children, is that correct?
That's correct.
And you heard me explain to the court that there was a prior judgment which determined the validity of the last will and testament dated January 15th, 2020. Are you named to serve as the independent executor under that will?
Yes,
And are you qualified to serve and continue to serve as the independent executor of this estate?
yes,
You are a resident of Texas of sound mind and not otherwise disqualified?
yes.
And is there a continued need for the administration of this estate?
I don't,
This marks the beginning of formal testimony. The attorney is establishing foundational facts required for probate, such as identity, death details, and executor qualifications, to satisfy statutory requirements for admitting the will.
know how to answer that.
Are you currently holding assets that, well, let me ask this, are there still some outstanding minor bills that would need to be paid on behalf of the estate?
Yes,
And would you need to then distribute those assets to the ultimate beneficiaries in your capacity as the executor?
yes,
And so with that in mind, would you agree that there is a continued need for some minor acts of administration before this estate can be closed out?
yes,
And to the best of your knowledge, this will does not leave a gift to any charity or governmental agency. Is that correct?
correct.
No further questions.
All right, Mr. Mestamaker, anything?
I think that's perfect.
All right, well then, following that jury's verdict, if there's any question, we admit the will of January 15th, 2020 into probate. Appoint Miss Lowe as independent executor. Miss Lowe, there'll be a inventory that'll be due in 90 days.
Okay,
And then has anybody e-filed a judgment?
And that is my fault, Judge. I said that I would make a few changes because in the judgment, we need to actually set aside the admission of the prior will and revoke her prior letters. So I'm adding that to the proposed draft that Mr. Mestamaker sent me. I apologize for the delay. I thought we'd have it yesterday, but as soon as I get his approval, I will e-file that and then send a courtesy copy to your clerk as well.
Okay, so get that e-filed. And then is there a document for Miss Lowe to sign, the proof of death?
Yes, I will have her sign the proof of death, just kind of confirming the other information she testified to as well as her oath.
Okay, so I'll just need to get that, the proof of death will get filed with the clerk. Miss Lowe, there'll be two documents for you to sign. One is called a proof of death and the other one is the oath. And so when I get that, and then I'll get the judgment, I'll sign that, and then you can get letters testamentary so that you'll have authority to close out the estate.
Okay, great.
Okay, all righty. That's it. Thank you.
Thank you, everyone.
Have a great day.
Bye-bye.
Bye-bye.
This hearing demonstrates how even seemingly simple probate matters require precise legal steps, from validating prior judgments to confirming executor authority and final filings. Each detail ensures the estate is administered lawfully and efficiently. Stay tuned for more courtroom breakdowns where we simplify complex legal proceedings into clear, practical insights.